This is Musings and Counsel from London Baker Law with Debbie London Baker.
Many people think estate planning, I have to have, millions of dollars. That's not true, is it?
No, no, no.
That
For,
word estate,
yeah, right. No, any money in the bank that you don't have a name on for somebody to get it when you die, that's an estate. And I've had people recently say, "Well, it's only $300, $400." No, I'm not saying it's a lot of money. I'm saying that if you don't put somebody on that account to get it, that money could very easily be lost, because why would somebody pay $1,000, $1,500, whatever an estate planning attorney would charge to probate that estate when you're not going to even get your money back? So you want somebody to have access to that money, however little or much it is, and you never know. Because right now, let's say I've got a number of estates where they're waiting to finish, but there's a home involved. Well, especially in Florida, maybe not in the Northeast in the winter. Well, even in the Northeast in the wintertime, you got to leave the water on because you don't want the pipes to freeze. Here, you don't want the house to mold.
Yeah.
In Florida, right?
We don't have too many freezing problems here, do we?
Right. So you got to keep the power on. Well, if you have $300 or $400 in an account that somebody can get access to, that might cover your power bill for a couple of months if it's a small home and you're running AC at like 85 degrees, but enough to keep the mildew out. So people, and people go, "Oh, I never knew." I said, no, and there's no reason for you to know. No, there's not, but it's just so they'll go off and they'll beneficiary designate. And I've gotten adamant about second level beneficiaries. So do you have children, Steve? Steve, do you have children?
I guess I did. Well, they're adults now.
Okay, they're adults, right? So
hearing the word children.
Okay, so they're adults. So
Yes.
a lot of times people will name their adult children, whether that's an 18-year-old or a 48-year-old. They'll name their adult children as their beneficiaries. But what I've started to say is you want to do the next layer down. So let's just say you have the 48-year-old as your beneficiary, but you have adult grandchildren, and that's where you'd want the money to go. I said, go name them secondary, because God forbid your child predeceases you, it may not occur to you in your grief that you now have an asset that doesn't have anybody to which it passes. And people say, "Oh, I never thought of that." I say, again, there's no reason for you to think about that. And in a state of grief, there's no reason it would occur to you. And if you have it in place, the likelihood of your grandchildren predeceasing you is minuscule. It's not much larger for your child. But if you have it in place, you've got it going somewhere, and nobody's going to run into a probate situation, which even in probate-friendly states, of which Florida is not, like, why bother?
This has been Musings and Counsel from London Baker Law. Learn more at londonbakerlaw.com. Thanks for listening.